Howdy. I'm Professor John Murphy, and I teach legal analysis at the Texas A&M School of Law. This is the third video in the series 10 Minutes Toward Mastery. In this video, we're going to discuss basic rule synthesis. Now, I find that rule synthesis, more than any other analytical skill, frightens first-year law students. Students frequently come to me and say they just don't understand what they're supposed to be doing when we ask them to perform a rule synthesis. They don't know how to do it. They'd like to cover it again. Well, in this video, we're going to talk about basic rule synthesis and maybe demystify what rule synthesis means. Now, at its heart, rule synthesis is actually quite simple. All we're doing is taking partial rules from different sources of law and combining them into a complete holistic rule. Now, the sources that we use for those partial rules can be any sources of law. It can be two cases, which is typically what we mean when we talk about rule synthesis, but it could also be a case and a statute, or two statutes, or any combination of different sources of law. The best way to understand this is to look at a couple of easy examples, so let's jump right in. Again, we're going to be using for our first example the Texas Driving While Intoxicated Statute. And as with the other videos, links to all of the legal sources that I'm going to talk about appear right below this video in the description. If you click Show More, then you can see links to all of the different documents that I'm talking about and follow along as I synthesize these rules. Okay, as we saw in the first two videos, the rule for determining whether someone violated the driving while intoxicated statute in Texas is a person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. Okay, we've already seen that to understand what intoxicated means, we have to look elsewhere in the statute, elsewhere in the code for a definition of that term. And that brings us to our first important point of rule synthesis. Lawyers never assume what the terms in a rule mean. We are always going to look at other sources of law to see if those terms are defined. And it's important to look at other sources of law. You might be tempted to look at Black's Law Dictionary to determine what intoxicated means. And for sure, Black's Law Dictionary has a definition of intoxicated, but the definition is quite different from the statutory definition in Texas. Black's Law Dictionary, as helpful as it is not a source of legal rules. The Texas Penal Code is, so we're going to look for that definition in the Texas Penal Code. Okay, as we've already seen, intoxicated is defined by the Penal Code. Just to recap that very briefly, intoxicated means not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination or two or more of those substances, or any other substance into the body, and this is the part we left out before, or having an alcohol concentration of 0.08 or more. Okay. What does drug mean? Why is drug listed and then dangerous drug is also listed? Well, those terms are going to be defined someplace, probably elsewhere in the Penal Code. We're not going to bother to look those up. Instead, we're going to look at a couple of other terms within this definition of intoxicated. The one we're going to focus on now is alcohol concentration of 0.08 or more. Alcohol concentration is another term defined by this same set of definitions, and it says that alcohol concentration means the number of grams of alcohol per 230 liters of breath, 100 milliliters of blood, or 67 milliliters of urine. So you see, to understand what the definition of intoxicated means, we have to look at yet another definition. And we could keep going, look up drug and dangerous drug and controlled substance to see exactly what the legislature meant by those particular terms. Looking up these definitions is probably the easiest kind of rule synthesis there is. We're taking the basic list of elements and then explaining what those elements mean by looking up the definitions for particular terms. Now, there are two other terms in the driving while intoxicated statute that are not defined by the Penal Code: operating and public place. To figure out what those mean, we'd actually have to look at judicial opinions to see how courts have interpreted those terms in the past. That too is part of rule synthesis. But we're going to stop right here and move away from the driving while intoxicated statute and instead look at the private nuisance rule from the multi-state performance test that we started to examine in the last video. This time we're going to do rule synthesis using partial rules from two different judicial opinions instead of from two different sections of a statute. Now, you need a little bit more background for this multi-state performance test. Basically, what our client wants is to stop someone from maintaining a huge dirt pile in the vacant lot behind her house. The cause of action that you could use to stop that kind of behavior is called private nuisance. That means someone is interfering with your use of the property, and it applies mainly to you as opposed to the public in general. That's why it's private nuisance. Our task is to decide whether she can get a preliminary injunction while the rest of her claim is making its way through the legal pipeline. A preliminary injunction is simply an order from a court that tells somebody to stop doing something during the pendency of the rest of the litigation. So she's trying to stop this dirt pile temporarily now. That's with the temporary or preliminary injunction, and she wants to stop it forever with her claim for private nuisance. Okay, that's all the background you need before we delve into the rules. Again, the information, the materials for this multi-state performance test are linked in the description to this video. Okay, this multi-state performance test includes two judicial opinions, and the first judicial opinion, the TIMO opinion, contains the rule for preliminary injunction. Our client is entitled to a preliminary injunction if she can prove these three elements. First, that she's likely to succeed on the merits of her underlying claim. Second, that she's likely to suffer irreparable injury if the court does not grant the temporary injunction. And third, that the balance of the equities weighs in her favor. And what that means simply is that it's fair for the court to stop the defendant from maintaining this dirt pile. Okay. That first element, likely to succeed on the merits of her underlying claim, requires us to look at the underlying claim, private nuisance, and see what the elements of that claim are, and then determine if she can prove all of those elements. So now we switch over to the other case, the Parker case, which contains the definition or the elements of private nuisance. According to the Parker judicial opinion, a private nuisance, or to prove a private nuisance, the plaintiff must establish that the defendant's acts are the proximate cause of the interference is unreasonable, and the defendant's interference results from negligent or intentional conduct. So, this is another elements test inside the first elements test. Now, in the last video, we looked at the test for that second element of private nuisance, whether the interference is unreasonable, and we saw that that is itself a factors test where the court has to consider 4 factors to determine whether they weigh in favor of the plaintiff or the defendant. So when we've put together all 3 parts of the rule, we have synthesized a complete rule that tells us what our client has to prove to get that preliminary injunction for private nuisance. Now, this has been basic rule synthesis. Rule synthesis can be more complex and nuanced, especially when you're dealing with multiple judicial opinions, and especially when those judicial opinions do not clearly set out the parts of the rules that the court is applying. But this is basic rule synthesis, and the goal of this video was simply to demystify the process a little bit so that you have a better understanding of what you need to do when synthesizing a holistic, complete rule to apply to a given set of facts. I'm John Murphy, and this is the Texas A&M School of Law.